Welcome to chapters 11 and 12 of Family Law. I hope you guys are doing well. I'd like to start out by talking about a few housekeeping matters. I would like to first talk about your family law project. Um, I would like to assign you a case. Um, I would like to have you look it up on Lexis, and I would like for you to do what is called brief this case. Um, as you do paralegal work within the framework of a law firm, you will do legal research. And when you find cases that are relevant in your research, you will need to read these cases, and you will need to summarize in a very particular way for your supervising attorney. And in that way, you will need to be able to give it to them in a way that they can use it, um, uh, in a way that they can use it for their purposes. And so I want to teach you how to do that. And so I picked a case that I think that you will think is interesting, and a case that is relevant to what we're doing in family law. So the case is Stone v. Gulf American Fire and Casualty Company. That's Stone versus Gulf American Fire and Casualty Company. And that's the site is 554 Southern 2nd, 346. 554 Southern 2nd, 346. And briefly, it has to do with the family of the country music legend Hank Williams. Hank Williams, as you well know, probably has a son, Hank Williams Jr., and everybody knew that his son was Hank Williams Jr. It was a kind of a poorly kept secret that he had a daughter that he had given up for adoption, and her name was Jet Williams, and and she had he given up her up for adoption, and she was living with her adopted family, and then she I believe went off to the University of Alabama, and kind of was dumped into the great melting pot at the University of Alabama, and she and gradually, I think, became aware through the whisperings down there that she, that she was kind of the heiress to one of the heiresses to the throne of the Gray Williams music family. And so, this is about her coming into her own legally to the Williams family, and kind of legally how she how she how she laid claim to her uh, legacy. So it's very, very interesting. And so let's talk a little bit about how to brief a case. So if you're looking for cases, and you find a case that you think is relevant to a certain issue, and you want to summarize that case for your supervising attorney, this is the outline of how you need to do it. And this is how I want you to do the Stone versus Gulf American Fire and Casualty Company case for me. So you need to, of course, state the case and state the site of the case clearly. And then you need to You need to give the history of the case, all the courts that the case has come through to get to the court that it now is in front of. So the legal history of the case. And then you need to summarize all the facts of the case, the relevant facts of the case. Then you need to summarize the legal issues, the pertinent legal issues of the case. And then you need to summarize the how the legal issues were decided in the case. How did the judges decide the legal issues? Then, if there is a dissent in the case, as there is in this case, if there's a juicy dissent in the case, talk about that as well. If it's worth talking about, talk about it. And then also always make sure that you shepherdize your case. If there's a noteworthy shepherdization in the case, then note it. So this Stone versus Gulf American Fire and Casualty Company brief as your family law project will be due on the day of the final exam, which will be on whatever day it says on the syllabus. I'm looking at it right now. I'm trying to find it for you. Sorry. May the 4th. So I'll post it on May the 4th, the exam. So that'll be the day that it'll be due. And if you'll just turn it in to me on Blackboard, that'll be fine. Okay. And then also I wanted to let you know that I've thought about the final exam, and considering the fact that we've not had a chance to be together, and just considering all that's been going on, and and everything, I don't really see any need to make the final exam comprehensive from chapter 1 to the final chapter. You've already taken the first half, so let's just make the final exam from chapter 6 through chapter 13. So the final exam will cover 6 through 13. Okay? And it will be open book. And obviously you will take it online. And there's really no need to do the safety lock or whatever it is that they talk about. I've heard people talk about it since I don't have any problem with you doing the open book. So I'll post it on Monday, May the 4th, and I'll post it for the time that the normal class period time, and you'll have that amount of time to take it. And we can talk about it some more next week. Okay? If you have any questions, just let me know. All right? Okay, let's talk about, let's go to chapter 11, determining parentage. Okay, so as you can imagine, in early American law, children who were born outside the connective threads of marriage were not given many rights. And however, as we moved along, the idea of family was expanded. And once we started moving into, once we started moving forward in time, the idea of family and the way that we viewed children started focusing on the well-being of children instead of and the not only the well-being of children, instead of being the child of no one, since they weren't the product of marriage, non-marital children were now formally recognized as children of their mothers, and they were mothers were entitled to custody and were also obligated to support their children. In starting as early as 1823, most states began to allow for legitimation, where parents married each other after the birth of a child. So that was a big step. And in 1968, the Supreme Court of the United States in Levy versus Louisiana held that it violated the Equal Protection Clause, that the state of Louisiana violated the Equal Protection Clause by denying children the right to recover economically for the death of their mother under the state's wrongful death law because of their illegitimate status. So the Supreme Court held that regardless of whether or not children were, whether parents were married or unmarried, children should be allowed to recover when their mother when their mother was the victim of wrongful death. Since then, the court has decided a number of cases involving similar equal protection challenges, but not always the same way. Sometimes the court comes down on one side and sometimes the court comes down on another, and really it doesn't always make sense. It doesn't always make sense to me. It just kind of depends on the circumstances. First, a court may carefully review any law that classifies children based on the marital status of the parents. The court must evaluate the reason for the statutory classification. If its purpose is to deter non-marital sexual relations or promote the state's interest in marriage, the classification is invalid because the goals do not justify the discriminatory treatment of children. Another case in 1972 in Stanley versus Illinois, the Supreme Court held that where a man and a woman had lived together on and off for 18 years and had 3 children. When the mother died, the state initiated a dependency action saying that the children were dependent. In other words, saying that the father couldn't take care of the children, and saying that the children were wards of the state. The father was not even provided an opportunity to care for the children. So he challenged the presumption that he was an unfit father, and he argued that he was entitled to a hearing on his unfitness, and the court agreed that he couldn't be deprived of his custody without a hearing, and that he had the potential for a meaningful relationship with his children, that fathers and children had the potential for a meaningful relationship, even though the parents were unmarried. And, this made it seem like, that the court might be moving in the direction of eliminating all distinction between unwed fathers and other parents. So, what makes an unwed father a father? So after the court in Stanley versus Illinois in 1972, a number of fathers got together and brought lawsuits challenging state laws that permitted the adoption of non-marital children based solely on the consent of the mother. So a number of states had laws that allowed mothers to okay the adoption of their children just because the fathers, they weren't married to the fathers. And so the unwed fathers, they challenged this. They didn't want it. And they said that an unwed father has a constitutionally protected right in maintaining that parental relationship with a child. Even though I'm not married to the mother, I still have a relationship with my child, independent of being married to the mother. And it can't be taken away without my consent, absent proof of my being an unfit father. And that treating me different than unwed mothers, than the mother, violates my equal protection rights under the Constitution. And in responding to these challenges, the Supreme Court answered the question left open by the Supreme Court in Stanley versus Illinois in 1972. In the 1983 case of Lair versus Robertson, the Supreme Court clarified the rights of unwed fathers and said that these rights don't spring into being based solely on the biological link between father and child. According to the Supreme Court, the significance of the biological connection is that it provides a father with the unique opportunity to develop a relationship with his offspring. that if he grasps that opportunity and assumes some responsibility for the child, he may be entitled to benefits and rights that attach to his parent-child relationship. However, if he fails to grasp that relationship, he can't claim a constitutionally protected right to participate in the adoption decision. So that biology alone doesn't make a father. They call this the biology plus approach. That biology doesn't make a father, but that it provides the basis for him to then, it's the opening for him to then go on and develop a relationship with the child. And that if he doesn't go on and then develop a relationship with what is a biological link, if he doesn't go on and develop a hands-on relationship with that child, then there's nothing there. Personally, this is just on a personal note, to me that doesn't make much sense, because I don't think that's very equal as far as equal protection goes. To me, that doesn't make a lot of sense, because, what do you think? That to me, that's not very equal as far as mothers and fathers go, because with mothers, biology is enough. They don't question mothers. Their biology is enough. And fathers, you have to have biology plus. So I don't really understand why they set up this elaborate test. So the court confirmed this biology plus approach in the 2001 case of Nyan versus Immigration and Naturalization Service, in which it upheld a gender-based provision in the federal derivative citizenship law. The provision automatically conferred citizenship on a child if the mother was the parent. But if the father was the parent, he had to establish his paternity and agree in writing to support the child. So if the mother was the parent, the child was automatically a citizen. But if the father was the parent, he had to first establish his paternity and then agree in writing to support the child. The court explained that fathers and mothers are not similarly situated with respect to biological parenthood. The court said that given the proof of motherhood that is inherent in birth itself, it is unremarkable that Congress did not require the same affirmative steps of motherhood, of mothers. So the court admits that it is requiring extra steps of fathers because I think it's saying that it requires extra steps of fathers because fathers can just I think it's because mothers it's just saying that mothers and fathers, it's saying mothers and fathers are differently situated. And so it requires a different test for fathers, and it's okay with that. This is on 557. On 558, in 2017, the case of Sessions versus Morales Santana, Justice Ginsburg, though, girl power, Ruth Bader Ginsburg. The court, however, in this case took a different approach and allowed citizen mothers who had lived in the United States for 1 year prior to a child's birth to transmit citizenship to a child born out of the country. Whereas a father was required to have lived in the United States for 5 years prior to the child's birth. But in this case, though, the court, via Justice Ginsburg, held that it was unconstitutional to impose a longer physical presence requirement on the fathers. And it says that it did not declare that all such distinctions are invalid, but it did declare that this distinction was invalid. Okay. So, on page 560, establishing paternity. The two primary approaches to establishing paternity are adjudication and acknowledgement. Acknowledgement is a voluntary act. It's when a father comes forward and voluntarily acknowledges that he is the father, a biological father of a child. Adjudication is when a court rules that a man is the father of a child. In 1973, when Congress entered the child support area, it passed the Child Support Enforcement and established a Paternity Act. And that was the beginning, really, the big beginning of the government's entrance into this area. When paternity is contested, states must, under federal law, have procedures in place that require the parties and the child to submit to genetic testing if requested by either party. And if the case is being handled by the state agency, here it's DHR. Some places it's called other things. But the agency must pay for the testing. So here, anywhere you go, it has to be available for free if that's what you choose. However, the state agency is entitled to recoup the funds down the road from the father if paternity is established. Unless an objection is made, the test must be admissible without foundation testimony or proof of authenticity. So once the test is done, the test is admissible in a hearing for adjudication. Under federal law, states must have rules in place that create a rebuttable presumption of paternity if the tests indicate that the man is the father of the child within a threshold of probability. So these tests are, nowadays, these DNA tests show within like 99.999% of probability whether a man is the father. I mean, they're like crazy accurate. So once they do these tests and it shows that a man is the father, they have to be able to present these tests. Once you submit to them, you are agreeing to their admissibility. And the state has rules in place, and they create a rebuttable presumption of paternity. When I say rebuttable presumption, that means that there's a presumption of paternity, but you can rebut it under certain circumstances. You can present evidence of a couple of things, like absence from the state. Like, I can't be even though it obviously shows that I'm the father, I can't be because maybe I wasn't there. Absence from the state, or evidence of sterility. You could use evidence of those to rebut the presumption. Okay, so Exhibit 11.1. (11.2) is a voluntary acknowledgement of paternity. And on 568, before signing a voluntary acknowledgement of paternity, one would want to and have to be provided information about one's legal rights and the legal consequences of establishing paternity. And there is a set window of time within which one can rescind their acknowledgement, their voluntary acknowledgement of paternity. If it's not rescinded, it operates as a legal binding or a legal finding of paternity. And it will be respected by other states. So following a determination of paternity, once that finding of paternity is established, then that is the legal father of the child. No matter what the actual circumstances were or anything, once that finding of paternity is established, that is the legal father of the child, with the rights and the responsibilities, as they say, thereunto appertaining. He can be required to pay child support and can seek court-ordered custody and visitation rights. If the paternity is established in court, a child support order can usually be established at the time. Now, if the paternity order, the adjudication, if the paternity was established in district court, that father may have to go to circuit court, for instance, and seek child support and visitation, and address visitation and custody. He might have to go to a different court to seek those, but they nevertheless can be addressed. Excuse me. So your book talks about disavowing or disestablishment of paternity, and it talks about it in terms of what makes a father. And this is a good question to talk about. because it brings up a good question, I think, in general to talk about. And I wish that we were really together so that we could have a good discussion about this. In any kind of law class, I think it's a good idea to talk about the difference between policy and law. Public policy questions are ones that talk about what is good for society. What do we want to encourage or discourage in society? What do we want to encourage in fathers? What are we looking for in fathers? What are we not looking for? What do we want to discourage in fathers? And on the other hand, as far as law goes, the law, as opposed to public policy, which is big, obviously, if we're talking about what are we looking for in fathers, we're talking about big picture ideas, But the law, on the other hand, uses a microscope. The law is tiny. It picks, is it, do we have, is it this? Do we do this? Do we do that? And so the law looks at the tiniest things. And we're not always, the law is not equipped to define what public policy is after. And so when we ask the questions about, what are we looking for in a father, I don't think we're not going to get there by using the law. So let's for instance, let's look at. Let's talk about. Well, let's just start by looking at this disestablishment. They asked some very good questions with regard to this. Do we want to offer these fathers who maybe have been tricked into signing a voluntary acknowledgement of paternity? Do we want to give them a chance to disavow if they find out that they're actually not the biological father? Do we want to give them a chance to disavow? That sounds only right, really. If they find out that, actually they thought they were the only one, but in fact they were one of about 5 or 10 guys during that time. It sounds only right. But then again, they were an adult in that situation along with the other adult. But really, there was only one innocent party in that situation, and that was the child. And if you allow them to disavow parentage and, back out of that situation after, signing a voluntary acknowledgement of paternity, then, that leaves the child with no father. And, the child didn't do anything wrong. And that leaves a child without a father. And like I said, the child was innocent in that situation. They didn't do anything wrong. And they're the only innocent one here. So, at first it looks easy, but not so easy, really. And, when they stepped forward as a father, they probably said, I'm doing this because it's the right thing. I want to do this for the child. I've been the child's father. I've acted as the child's father. And then, now suddenly it's not so much. Then you have the question, if you allow him to disestablish paternity, then what impact does that have on his child support obligation? Do you allow him to stop paying his child support? Do you allow him to recoup all his past child support that he's paid? Do you allow him to get paid back all that child support? What do you do? Recently, I had a case where a situation where a child had a child had a father and a mother who were unmarried, and another man came forward and said he was in fact the biological father. And I'm sorry, excuse me, let me back up. He had a mother and a father who were married, and that father had been his father, and they were in the process of getting a divorce. And there was another man who came forward and said he was the biological father, and he wanted to be tested. And so he came forward and was tested, and DHR conducted the testing of the man who said that he was the father, and of the child, and of the man who was married to the mother who had been acting as the father for all these years. And it tested out that the man who had come forward, that he was the biological father. And so the man who had been acting as the father all these years, he disavowed fatherhood. And the man that had come forward, he was established as the biological father. And we presently have a termination of parental rights hearing presently scheduled to terminate the new biological father and the mother's parental rights, because DHR says that both of them, the new father and the mother, are unfit, and that the foster parents should have custody and should be allowed to adopt. So, yeah. um, things get a little more complicated when you deal with when the genetic father is not an actual person, but when the genetic father is a sperm donor. As you can imagine, most states have not kept up with the times. Obviously, that is not as uncommon now as it used to be, and a lot of people are turning to that. Um, Even though most states have not kept up with that as a legal reality, I think most people, um, uh, instead of relying on state law to back them up, um, either in the case of a problem, if they plan to use a sperm donor, either as a heterosexual couple married, or as a homosexual couple, um, either the partner adopts the child, or they try to have an ironclad agreement, so that it's a contract. Um, so the law of the state would only come into play if those two things did not cover the situation. So the law that we're talking about here would only come into play if there was no adoption and no contract law. So let's talk about that. If you have a married couple that are unable to conceive due to infertility, it's possible that they would use a sperm donor. And, excuse me, a lot of the we previously discussed the common law presumption of paternity when a married couple has a baby. It's presumed that the father is the biological that the husband is the biological father, and that's the presumption of paternity. And however, it's not absolute. It can be rebutted by a proof of infertility or a lack of genetic link. And but to address the situation in 1973, they adopted the Uniform Parentage Act, and the Uniform Parentage Act included a donor cutoff provision, which established that the donor is not a parent of a child conceived by assisted reproduction, with a corresponding provision served to vest legal fatherhood in a consenting husband. In 2002, the National Conference of Commissioners on Uniform State Law amended the UPA, the Uniform Parentage Act. And in relevant part, it had the rules regarding donor insemination were updated. And first, the requirement that the insemination had to be done under the supervision of a physician in order for the donor cutoff or the paternal consent provisions to apply was dropped. And second, the marriage requirement was dropped. So a man who consents to the insemination of his partner with the intent to be a parent, a man who consents to the insemination of his partner with the intent to be the parent is the parent of the resulting child. And the Uniform Parentage Act, as revised in 2002, further provides that the absence of a signed consent does not preclude a finding of paternity where a couple resides together during the first 2 years of a child's life and the man holds the child out as his own. The 2002 UPA also adopted a gender-neutral mandate. So, but you need to remember that although a lot of states have the UPA, including Alabama, only a few states have adopted the 2002 UPA, and Alabama has not. So I'm sure that does not surprise you. So Alabama does have the Uniform Parentage Act, but does not have these 2002 updates. If you are in Alabama and you want to you are a same-sex couple and you wish to co-parent a child, the safest way to do it is to the safest way to do it is to adopt the child, and to also have an ironclad written agreement as well, contract. Let's see. Let's move on to Chapter 12. Child abuse and neglect. On page 604, the colonial period, I love the way that they describe the historical view of the need for child correction in the home, the need to stamp out the stain of sin in the child that marked each child at birth. What chance do you have as a child with that as the goal? No wonder people went overboard. Gosh. I do a lot of work with children as a guardian ad litem. And, I really appreciate you guys' patience with me over the last 2 weeks, or the last week, I should say. Actually, the reason why I am a week late with my lecture is I have had a case that I've been working on, and it is a juvenile case, and I think that right now, the COVID-19 situation has just put a lot of pressure on everyone. But I think cases with children, um, have been made especially more perilous, um, because, whenever adults feel more pressure, it seems that they put more pressure on their children. And it's because I think that there's just really nowhere else for it to go. And it's because um, children don't have voices. Um, and other other than the ones that we've created in the system. And if we don't maintain those voices, if we don't make them active and reactive and open, and if we don't keep listening, and if we don't keep DHR and guardians and CASA, and if we don't keep volunteers, if we don't keep all those people listening and doing their jobs all the time, constantly, and make them a priority, then then it's really easy to make them the the steam valve outlet for everyone. It's just like the whole thing, the boss kicks the employee, the employee kicks the so and so, then it kicks the whatever, and they kick the kid. And I mean, what's the kid gonna do? I mean, they don't know who to tell or what to do. And would be that that's all there was, is just a cuff, but that's not all. And would be that they just, but when we take out our stress and our frustrations and everything over and over and over again on our children, eventually what happens is they start acting out as well. And they start acting out against other children in in all kinds of ways. Um, they start acting out emotionally in angry ways against other children. They start acting out against other children in violent ways. And they can also start acting out sexually against other children. So then we're talking about victimizing other children. Children can start victimizing other children. This is not unusual. So during this time, that can happen. That happens all the time. But, during times of extra stress, extra pressure, like right now, this is even more an issue. So even this is even more a priority right now. So let's talk a little bit about the beginning of the institutionalization of child abuse. So in 1874, actually supposedly there was a girl named Mary Ellen. It was a 10-year-old girl who was being brutalized by her foster parent. And she was seen by a worker who appealed to the American Society for the Prevention of Cruelty to Animals. She didn't know. I don't think the woman even knew who to turn to, because there wasn't a place. And so I think she just thought, gosh, I mean, you wouldn't even do that to an animal, much less a child. And so they actually So the ASPCA took it to the court, and they convicted the foster parent of assault and battery. And Mary Ellen was committed to an orphanage and entrusted to a new family. And so as a result of this, there were several societies in several different cities that emerged in a variety of cities and towns. And they saw themselves as an arm of the police. And as their goal, their goal was to see existing laws enforced. They could arrest offending parents, search homes, look for evidence of child abuse or neglect, remove children, and to initiate prosecution of offenders. And this kind of reached its peak in the 1920s, and then just kind of died down again. In the 30s, if you think about it, it was during the Depression, when everybody kind of died down during the Depression, when everybody was just so concentrated on survival. And everybody just kind of, if you think about it, they just kind of circled the wagons, really, and just were so concentrated on just, hunkering down and trying to figure out a way to survive. Close the door, batten down the hatches. Certainly weren't going to talk about what was going on at home, because they had to, shut the doors and close the windows and try to figure out a way to, get by. But then in the 1950s, when they, started figuring out new advances in X-ray technology, they started being able to identify patterns of injuries in children that were inconsistent with explanations that parents were giving about childhood accidents. So, when accidents were happening, these parents were taking their kids to the emergency room. They were doing X-rays. Parents were saying, "Oh, this happened to her," but the X-rays were showing something different. And so, child abuse reports were starting to, go up with that. And also the X-rays were revealing not only present injuries, but they were also revealing old injuries that had healed. In 1962, I thought this was interesting, a major study entitled "The Battered Child Syndrome" was published. And the study detailed the harms that children suffer at the hands of their caretakers. And within 5 years after the publication of that study, all states had enacted abuse reporting laws. And these laws focused on physical abuse and generally imposed reporting requirements. At first, the reporting requirements only had to do with doctors. A variety of agents, including the police and the juvenile courts and the protective agencies, were designed to receive these reports from the doctors. But unfortunately, the reporting agencies didn't really have anybody to take didn't really have anybody who was supposed to assume responsibility once the report was taken. So when they took the report from the doctor, they didn't really know what to do with it. And so it just kind of fell through the cracks. So as a result, Congress passed the Child Abuse Prevention and Treatment Act in 1974. In 1974, it was reauthorized and amended a few times. And it was coordinated And through it, Congress said, to every state, for every state that develops a coordinated child protective system, we will federally fund it. You will become eligible for federal funding. And so all states revised their existing laws and centralized responsibility in a child protection agency. And so now every state has a centralized, coordinated system to protect children from harm from parents or other caretakers. And they're charged with responsibility for receiving and investigating reports of abuse or neglect, providing services to families, taking children into emergency custody, and initiating court dependency and termination proceedings. Also, when they get reports of children being raped or receiving serious physical injury, they also can refer those to the district attorney. Let's see where we are. Yeah. Okay. So what is physical abuse? Physical abuse, the definition of physical abuse may differ depending on where you live in the country. The definition of physical abuse in New Hampshire for a New Hampshire Child Abuse Protection Agency worker may differ from a reporting agency in Lawrence County, Alabama, for instance. A parent who occasionally spanks a child in accordance with his or her understanding of appropriate boundaries in Alabama, for instance, that may not be a big deal. No marks, just that may not be considered physical abuse in Alabama, whereas it might be in another state. I don't know. Whereas sexual abuse is another story. Sexual abuse encompasses a range of actions from inappropriate touching to penetration. Unlike sexual assaults by strangers, incest by a family member often begins with nonspecific sexualized touching and gradually evolves into more overt sexual acts. Generally speaking, sexual abuse usually entails secrecy and is often the child is usually sworn to secrecy, or the child may be threatened with great harm if they make a disclosure. Sometimes the child is told that if the child tells what's been done to them, that maybe that that the abuser will hurt their family or their friends. Because sexual abuse is cloaked in secrecy, and obviously the physical manifestations of the abuse are lacking, it can sometimes be difficult to detect. At some point, a child may reveal what's been happening or may inadvertently say something without meaning to. And that may be done when a child complains about physical problems, such as vaginal soreness. When actual physical manifestations happen, such as vaginal scarring or a venereal disease, are noticed during a physical examination, or when an adult becomes concerned about unusual or developmentally inappropriate behavior, these are other ways that it can come to light. And I was talking about earlier about children sexually acting out against other children. And this is a way that sexual abuse is discovered, is when you have a child sexually acting out against another child. That is usually evidence that that child has been sexually abused. Children don't make this kind of behavior up. They learn it. So, if you have a child who's sexually acting out against another child, that may be evidence that they've been sexually abused. They've learned that behavior from an adult. Emotional abuse is defined or involves subjecting a child to intense and reoccurring anger or hostility. The abuser may constantly belittle or scapegoat, threaten, insult, or verbally assault the child. Prolonged isolation or acts such as locking a child in a closet can also constitute an emotional abuse. Emotional neglect usually refers to the withdrawal of love and affection for a child. State intervention based on emotional abuse or neglect alone is rare, just because usually it comes along with another kind of abuse. And usually the symptoms are difficult to identify and tend to emerge gradually over time. And I don't know. I just think the book is saying that it's easier to come down on one of the other kinds of abuse. I think the reason that makes the most sense that the book talks about why parents aren't picked up for emotional abuse and neglect alone is that, it's difficult to determine the standards that parents should be held to. Like, what is emotional abuse and neglect? There is an extreme that you can identify, yes, but some people are cold. Some families are colder than others. Like in my family, we probably say I love you 1,000,000 times a day. And each time means as much as the time before or the time after. But a lot of families don't say it very much at all. But if you brought it up, they probably would be surprised. Like, of course we love each other. No, we're not. We love each other. What are you talking about? They probably wouldn't understand what you mean about them being cold. We're not, no, we're not emotionally abusing our children. And, their children might even not understand what you're talking about. I don't mean just because they're not saying that they love their children. I mean, just, how much love is enough. It's hard to decide what standards to set for everybody. Neglect is another matter, really. Neglect is the failure to provide for a child's basic needs. It's a broad concept that encompasses a range of acts, including the failure to provide food, the provision of unsanitary or unsafe housing, and the failure to obtain adequate medical care and related services. Lack of supervision, neglect of personal hygiene, and educational neglect. I thought it was interesting. Your book said that reports consistently indicate that more children suffer from neglect than any other form of parental maltreatment. And I've certainly found this to be true, like in the cases that I've dealt with regard to DHR, that, there's just so many cases that I've dealt with where just, I've had cases with houses where just rats running across the floor, cases where, kids, fleas all over their arms and legs, a case where, 1 week the power's on, 1 week the water's on, but the lights are off. The next week the lights are on, but the water's off. Just open up the refrigerator, there's mustard, but that's it. There's nothing to eat. God knows, when the last time the kids have eaten. So that's pretty much, I think neglect is over the board. I don't have a problem believing that. So, your book talks about the issue of neglect lying not in failing to protect a child from actual physical injury, but rather in failing to protect the child from witnessing acts of violence. I'm not aware of a case like this in Alabama, but I know that there is a growing awareness in the criminal code of the criminality of committing violence in the presence of a child. If you commit a murder in the presence of a child, then it automatically goes, under the age of 14, it automatically goes from a regular murder to a capital murder now in the state of Alabama. So to me, that is a growing awareness of the fact that we recognize that violence in the presence of children has a huge effect on their developing minds. Okay, page 613, medical child abuse. So with medical child abuse, we're talking about the Munchausen and Munchausen by proxy situations. I don't know if you know much about that, but Munchausen is a situation where one subjects a child to unnecessary and potentially harmful medical care. Munchausen by proxy, is where a parent subjects their child to unnecessary and potential harmful medical care based on exaggerated or feigned symptoms in order to get sympathy for themselves. So, if I have Munchausen by proxy, then based on some mental illness that I have, a need for sympathy, a need for attention, then I create these, I subject my child to unnecessary and potentially harmful medical care by creating this feigned need for medical attention on their part. And this is not just something on TV. I mean, my firm has had 2 cases of it, I know. And it's been so sad to watch. And it's just gone on and on and on. It's very real. And it's hard to prove. But the more it goes on and the more that these symptoms are ruled out, the more obvious it becomes that there's only one explanation that's possible, and that is the Munchausen by proxy. Okay, let's talk about drug use by pregnant women. So what happens if one is pregnant and one uses illegal drugs when one is pregnant? Your book says that some states specifically require healthcare professionals to report suspected prenatal drug abuse to Child Protective Services. In Alabama, as there are in most states, there are what we call mandatory reporting laws. And what that means is that there are laws in Alabama that set out what we call mandatory reporters. And that makes doctors, all kinds of doctors, clinics, hospitals, mental health professionals, teachers, coaches, clergy, basically anybody who works closely with children, and any kind of medically related professionals required to report any incidents of child abuse at all. And so if in the instance that a mother tested positive for an illegal, So in Alabama, if there is an incidence of child abuse, those people are required by law to report it. If they do not, they can be held criminally liable. Now, there was a case in Alabama. The case was Kimbrough, Kimbrough, in Alabama. And that case now stands for the ruling that if a person tests positive for illegal drugs, then a doctor, hospital, clinic, etc. has a duty to report them. For child abuse to DHR. So let's think about that for a minute. Is that a good thing? So we talked about the difference between law and public policy. So the law is that if they go to the doctor, that they go in for prenatal care. They go to the doctor for prenatal care, right? That's a good thing, right? And for some reason they conduct a blood test or something, and it turns up that they've been using drugs. Then they report them for child abuse. Then probably what's going to happen is they're going to take their baby when it's born. Okay, so that's the law. But what's the public policy result? What's the public policy result of that law? What's going to be the public policy outcome of that law? I mean, what are these mothers who get pregnant and who have, who may be kind of on the edge, are they going to be more or less likely to seek prenatal care? Are they going to be more likely to go in and ask their doctor's help, when they get pregnant? Or are they going to be more likely to be afraid to go in for fear that they're going to get their baby taken away? So, when we pass a law like that, we should be thinking, at the same time, how can we balance the law and public policy instead of passing a law, in my opinion, passing a law, that's so passing a law that has the effect of keeping prospective mothers potentially has the effect of keeping potential mothers from seeking prenatal care. We should think about maybe passing a law that could balance that interest with our interest in preventing or addressing the illegal drug use. I realize that we don't want them using illegal drugs, but maybe we could address that instead of just thinking about prevention. Maybe we could address it and balance that with still wanting them to come in and talk to their doctors when they are in the prenatal stage. I think we threw the baby out with the bathwater on this. All right, so let's talk about, we talked about mandatory reporters on page 615. Okay, 617. When a state agency receives allegations of child abuse or neglect, and they find that that the allegations are substantiated, the Protective Agency has a duty to make reasonable efforts to keep the family together before it seeks to remove a child from the home and place them in foster care. If a child is removed, the agency must again make a reasonable effort to reunite the child with his or her family. The Child Welfare Act, which was passed in 1980, was enacted in response to concerns that too much of an emphasis was placed on on family preservation, and they sought to replace the replace the they felt like they needed to kind of the state felt like it needed to speed up the process a little bit. That it was taking too long from the time that they began the process, from the time that a report was made. Not that they didn't want to work with a family, but that it was dragging out too long. They wanted still had a responsibility to make reasonable efforts to reunite the family, but it was dragging out too long. So the Child Welfare Act, if removal of the child became necessary, and the state agency had made reasonable efforts to reunite the family, then in 1997, Congress passed the Adoption and Safe Families Act, and this fast-tracked what had become a drawn-out process under the Child Welfare Act. And it shifted the emphasis of the child protective system from the family preservation to, more importantly, child safety. Under the old act, Child Welfare Act, the emphasis on family preservation had put child safety at risk. And the Adoption and Safe Families Act shifted the emphasis, and it still preserved the reasonable efforts requirement, but still, it was able to speed up the process and still preserve child safety. So the Adoption and Safe Families Act allowed the state agency to work on two tracks at the same time. It allowed them to make reasonable efforts to reunite the family on one track, and still, and on the other track, just in case, it allowed them to work on a termination of parental rights track in case the parent reunification track didn't work. So it didn't make them wait on the termination of parental rights track until this one didn't work out, and let them just work both of them at the same time. So to meet their reasonable efforts to reunite the family requirement, the protective agency, or DHR in our case, must offer what's called supportive services to help parents care for their children more successfully. And the services that they offer can include lots of different kinds of things. And just for instance, like just some examples include daycare, parenting education classes, counseling, respite care, it can include physical therapy. It can include, anything you can think of. It can include all kinds of things. And basically, a service plan outlining the service to be offered the parents is developed, and it's called an ISP, an individualized service plan. And a group comes together to create the individualized service plan. And the group consists of usually the DHR worker assigned to the case, the parents, if there are grandparents involved, all the workers that actually conduct the services, like the occupational service worker, the parenting worker, any workers that actually give the services, the in-home workers, guardian ad litem, if there is any other parties that are represented by attorneys, like let's see. Like if there's a separate custodian for the child, that custodian may have a lawyer. Any other lawyers that are on the case, they are part of the team. Let's see. Oh, there may be other doctors that are involved. There may be, for instance, like there may be like a physical therapist. There may be a occupational therapist. There may be, so all these people come together for the ISP, and as many of them, hopefully as possible, come together each time to meet for the individualized service plan, to come together to create the individualized service plan. And some of them go very smoothly. We come together, usually not during COVID-19, but times, but normally we all come together in a room at DHR usually, and we sit down around a big conference room table, and the worker sits at the head of the table and has like a sheet of paper, and writes everybody's name down in it, and then starts writing out the plan, what everybody's going to do for that person. And, over the next 6 months. This is what everybody's going to do. This is the plan for everybody, what they're going to do for this child and these parents. And sometimes it goes very smoothly, and sometimes there can be conflict involved in the planning. Sometimes, parents don't agree with the services, and sometimes grandparents don't agree, and sometimes, sometimes it can be a little testy. So, when a child can be removed from a home if they are determined to be dependent, and if a court agrees that a parent cannot presently care for a child, if a parent or custodian is unable or unwilling to care for a child, then the child is adjudicated to be dependent. The custody of that child is usually then transferred to DHR custody, and DHR assumes primary responsibility for making decisions involving the child, and the child is then placed in foster care. If the child is adjudicated to be dependent, then the case moves into what's called a dispositional phase. And the plan at that time, then the ISP or individualized service plan is developed and then sets out what reasonable efforts or what services must be made in order to try and reunite the child with his or her family. A permanency hearing is held no later than 12 months after a child is entered into foster care, and so that the child is not left in limbo. There has to be somebody who is held accountable for that child on a regular basis. And, we have established DHR as that entity. DHR has its pluses and minuses, to be honest. The Department of Human Resources is a bureaucracy. It's not the same as having a person in charge. It's made up of people, and there are individual workers who have cases. So in that way, it is a person, I guess, but DHR is an entity. I mean, it is a bureaucracy, and it is governed by rules. And DHR is it does not. DHR plays by the rules that it has, and it does what its rules say, and only what its rules say, and it doesn't do anything else. So if there is a need beyond what DHR is supposed to do, it does not get it done. So, if there is something that needs to be addressed beyond what DHR is set up to address, then it falls through the cracks. So in that way, we fall short. Termination of parental rights is a remedy that permanently severs the parent-child relationship. And after the termination of parental rights, a child is freed up for adoption and can be permanently incorporated into a new family. Because termination results in an irrevocable change in parental status, it must be based on clear and convincing proof of parental unfitness. A court cannot terminate a parent's a parent's rights just because it believes that a child would be better off with another parent. It has to find that there is clear and convincing proof that a parent is unfit. Okay. All right, that winds up chapter 12. I believe chapter 13 is on adoption. And I will post this video on in your lectures tab, and I will post next week's lecture, same place, and then I will post your final exam, same way I always do. And if you have any questions, just let me know as usual. And again, let me reiterate, your family law project is to brief Stone v. Gulf American Fire and Casualty Company, 554 Southern 2nd, 346. Please look it up on Lexis. And please give me, first, the legal history. Second, summary of the facts. Next, a summary of the legal issues. Next, how the legal issues are decided in the case. And finally, I'd like you to discuss any legal dissent in the case. Please don't forget to Shepardize the document. I'm sure you'll do fine. Finally, don't forget that your final will not be comprehensive. It will be over chapters 6 through 13. Have a good day. Bye.